Dr. Angelo Sklavos was a doctor seeking to practice as a dermatologist. In order to practice as a dermatologist in Australia, a doctor must complete a course of training and examinations set by the Australasian College of Dermatologists. The assessment consists of written examinations, oral examinations, and clinical examinations. Dr. Sklavos attempted the examinations in 2010 but was unsuccessful, and following that unsuccessful attempt, he apparently developed a specific phobia of the examination, and this is apparently a psychiatric condition which qualifies as a disability under the Disability Discrimination Act. Dr. Sklavos applied to be admitted as a dermatologist without undertaking the examinations, but this was refused, and he regarded this as discrimination. The court found otherwise, but that's not really the point of this case note. If he was to sit the examinations, then he would need to have reasonable accommodations made to enable him to have a fair crack at the exam, despite his apparent disability. The rules for establishing this are set out in the Disability Standards for Education 2005 Commonwealth, a statutory instrument made under the Disability Discrimination Act. It is binding on education providers in Australia, and for this purpose the college counted as an education provider. The college offered a range of very reasonable and quite extensive accommodations, but in Dr. Sklavos' view these were insufficient. When it got to trial, the trial judge examined those accommodations and found that they were reasonable, and so dismissed Dr. Sklavos' claim. On appeal, Dr. Sklavos argued that the Disability Standards for Education didn't just require accommodations, they also required consultation between the education provider and the person with a disability. On appeal, the court agreed. Justice Bromberg in the lead judgment said, to meet the obligations, the education provider must discharge the consultation and consideration requirements. Clauses 5.2 and 6.2 are not simply result-driven. They are also driven by process. They require a process to be followed which, where appropriate, will provide a particular result, a reasonable adjustment. They do not merely require the particular result. Justice Bromberg found that the trial judge had not dealt with this question adequately in her reasons, but the other two judges disagreed and Dr. Sklavos' claim failed. From this case, we learn that education providers have a clear obligation to consult with any student with a disability, with a view to mutually identifying reasonable accommodations to offset their disability.